a couple of preliminary matters before we start this morning's proceeding. And then the third thing would be, other than the media and the people at council table, I'd ask that at this time all cell phones not merely be muted, but maybe be turned off for the proceedings. Okay? Okay. Yes.
We're on the record.
Morning, Your Honor. It's time set for change of plea and sentencing in matter of State versus Michael Nearman, 21 CR 20913. The defendant is present in custody, out of custody, accompanied by his attorney, Jason Short, for the record, Marion, representing the state. Pursuant to negotiations, Your Honor, I believe we've come to a resolution short of trial, where it's anticipated the defendant will be entering a guilty plea to count 1. The state will be moving the court to dismiss count 2.
Mr. Short.
Good morning, Your Honor. That's all correct. We are ready to proceed with the plea and sentencing. I have reviewed the plea petition with my client, and he's ready to proceed today.
Okay. Good morning, sir. So it's likely that a lot of the questions that I'm going to ask you are things that you talked to your lawyer about recently, okay? But I just want to go through them to make sure they're on the record. And then also, as I go through this, please understand that there's some questions that I will ask you that I ask everyone. So if they seem a little odd to you, just know that they're standard questions that we ask everybody as they ask the court to accept a plea. Okay? All right. So I have here a petition to enter a guilty plea in case 21 CR 20913. The petition is a 2-page document, and on page 2, about 3/4 of the way down, there is a name and a signature. Is that your signature? I see it here. So there's 2 sets of signatures. The first set of signatures, is that yours, sir?
Yes.
Okay. And then below that is your lawyer's?
Yes.
Before signing this, Mr. Nearman, did you have an opportunity to go through each of the paragraphs with your lawyer? And there's like 11 paragraphs. So did you have an opportunity each one there? Okay. All right. And what this petition says is that you, at this point, wish to essentially withdraw the plea of not guilty that you had previously entered to count 1, which is official misconduct in the first degree, and to enter a guilty plea. Is that your understanding as well? Okay. In asking the court to accept your plea, you're giving up certain rights that you are afforded by our state and federal constitution. They are in paragraph 2 and 3. I'm just going to go over them real quickly with you. I suspect that you probably read them all through. So you understand that you have the right to plead not guilty. You have to answer out loud because we're recording.
Yes, I think so.
And you understand that if I accept your guilty plea at the end of this discussion we're going to have, then what happens is that conviction gets entered on your record, and it will get entered in the court record. And because you pled guilty as opposed to going to trial and been found guilty, you give up your right to appeal the fact that you've been convicted of this charge. Do you understand that? Okay. And also, in a jury trial, you have a right to a jury trial. This is a misdemeanor, so it would be a 6-person trial. All 6 would have to agree that the state proved this case beyond a reasonable doubt. And in that jury trial process, you would have the opportunity to call witnesses if you so choose, or you would not have to because the state has the burden. You have a right to cross-examine any witnesses that the state brought forward. You have a right to remain silent throughout that entire process. But by giving up your right to a trial because you pleaded guilty, you're giving up all those rights as well. Do you understand that?
Yes.
Okay. All right. Now, this charge is a Class A misdemeanor, so that means that the maximum sentence that a court could impose upon conviction would be 364 days in jail and up to a $6,250 fine or both. So that's the maximum sentence. I understand, because I talked to the lawyers before I came in here, and I talked to the state's lawyer, that you've worked out a negotiated resolution. And so I'm not bound by law to accept the recommendation that they're going to make to me. Meaning that if you plead guilty, I could choose to sentence you to something else. If I did that, I would allow you to withdraw your plea, because I understand from talking to your lawyer that you've agreed to enter this plea based on the recommendation that the state would make and on the assumption that the court would accept it. Is that kind of how you understand this to go?
Yes.
Okay, all right. I've looked at what the state's going to recommend. I had some questions. They were able to address it, and so at this point, I'm prepared to accept the recommended disposition. So I'm going to go ahead then and ask you further about this guilty plea, okay? All right. Other than discussions that happened between you and your lawyer and the state's lawyer, did anybody else make any threats or promises or in any way try to influence you to plead to this charge? Okay, all right. And currently, are you on any sort of a medication, or are you under the influence of any substance that may affect your ability to understand what we're doing here this morning?
No.
Okay, all right. Have you had a chance to talk to your lawyer about your case? Are there any questions that remain that you would like to ask him?
I have talked to my attorney and I don't have any questions.
Okay, all right. So you're charged with, as I said, one count of official misconduct. Which says that on or about December 21st, 2020, in Marion County, Oregon, you then being a public servant, did unlawfully and knowingly perform an act which constituted an unauthorized exercise of your official duties with the intent to obtain a benefit or harm to another. Now, that's what it says. Are you admitting that you engaged in this conduct?
Yes.
And just can you tell me in your own words what you did that makes you guilty of this charge?
I opened a door in the Capitol, I went out, and that allowed people to enter, citizens to enter the Capitol.
Okay. And as I said, sir, this part of that, one element of this is that you would have done that with either the intent to obtain a benefit or to harm another. So can you tell me what that part was?
I had no intention of harming anyone. I suppose that the benefit would have been that I think that the citizens were allowed to be in the Capitol, so I was letting them in.
Was it a time when the Capitol was generally open?
In this case, the Capitol was closed to the general public.
So as I read this charge, generally it means that a person has acted with an intent to benefit themselves or to tangibly benefit another. So you're telling me that the benefit that you were seeking to confer was on the public and being able to enter?
Yes, yeah, I think so. One other benefit to me was that it provided the appearance that I was helping citizens enter the Capitol, so that made me appear favorable to certain citizen groups.
Did you know what they were intending to do once they entered?
No, and I don't support what they did when you
Okay. Sir, based on what you've told me, I do find that there's a sufficient factual basis for accepting your plea, and I would find also, based on the questions that I asked you, that you've entered into this plea knowingly, intelligently, and voluntarily. And so I'll go ahead and I'll sign my name on this plea petition, and that will cause it to be entered into the record of the court. Okay? It's your intent, I think, to proceed to sentencing at this point?
Yes.
And before that, Mr. Nearman, was there anything that you wanted to say?
No.
Your Honor, this is a stipulated agreement between the parties. We're asking the court to suspend imposition of sentence, place the defendant on 18 months of court probation. The conditions of probation would be that he successfully complete 80 hours of community service. That should be done through Cal. He is banned from the Capitol building and its grounds for the duration of probation. There should be a show of proof on April 11th, 2022 at 10 o'clock in this courtroom before Your Honor. Additionally, there's a misdemeanor fine of $100, a probation assessment of $100, and finally, the defendant is agreeing to pay $2,700 in restitution for damage done by the protesters to the Capitol building. That should be paid to the Oregon Legislative Administration, and that lists the address on the subject. On the face of the judgment, we'd ask the court to dismiss count 2 and charge of criminal trespass, which was really charged on the 8th of that period.
Mr. Sherwood.
Thank you, Judge. We ask that we follow that recommendation that's been negotiated between myself and the DA's office. That's all. Thank you.
And so, as I said to you, Mr. Nearman, I am going to go ahead and accept this recommendation. So, your sentence on the count 1 of official misconduct in the first degree will be the imposition of sentence will be suspended. You'll be placed on bench probation for a period of 18 months. What that means is that you don't have to go to the probation office. Basically, you'll report back to the court. And I've set a report date back of April 11th, 2022, so you come on in to this courtroom at 10 a.m. And it's just for purposes of checking on your progress. There aren't a lot of conditions on this. The conditions are that you perform 80 hours of community service work, and there are a number of ways that you can satisfy that condition. You're not to enter the Capitol building or the area around it, the curtilage around it. There is a general condition that I would impose that you obey all laws. There's a $100 fine upon conviction for misdemeanor. And then there's also a bench probation amount of $100. Those amounts are in addition to the $2,700 that has been ordered in restitution, and I would accept that order. Do you have any questions about the sentence? And I guess I just have one thing to say in closing. So elected officials take an oath to carry out their duties and to uphold the principles of our state and federal constitutions. You took one when you were elected in office, so did I. In doing so, we commit to the principles of our democracy. I don't know if you were listening to the hearings at the Capitol this morning, at the U.S. Capitol. But I happened to be listening to him before I came into work, and there was a Private Olson, who was a Capitol officer, who testified about his part on January 6th, and he said a thing that just stuck in my mind as I came in to work this morning, which is that democracy is bigger than any person, and it's bigger than any political party. I think he's right about that. I think that democracy is built on the principle that when there's disagreement, that starts the public discussion and debate. It doesn't end it. That's the province of tyranny and anarchy. And we're not that. We're so much better than that. And I suspect that we probably agree on that, you and I. Because I think that those are principles that we share. So, thank you. That concludes this matter. When is this?
We're off the record.